Welcome back to the Oxendine Law Podcast. It's a new year. Christine, 2020 Thrive. I think that's our slogan for this year, not 2025. It's 2020 Thrive. I'm your host, Jared Oxendine, along with my lovely and talented co-host, Christine Palmer.
Back for a new year.
Yes, let's do it all over again. Today's a good topic. We're talking about dividing assets. So we're talking about equitable division, which can be very complex. It can be emotional. It can be complicated. But if you follow our tips and you know what you're doing, we can turn what could be a complicated process into a very straightforward, seamless, easy process. So let's dig in and talk about dividing assets, marital property versus separate property. And that's going to be our first topic. What is marital property? What is separate property? I will start. Marital property are assets that are acquired during the marriage. So anything that you acquired during the marriage does not matter. This is a big misconception.
Right.
People think, well, this is my paycheck and this money went into my bank account and I'm the one that made this retirement money. It went into my retirement account and therefore it's mine.
Her name's never been on it. You don't understand. Her name's never been on it.
That's not how it works. Marital property is anything acquired during the marriage by either spouse. So if it's acquired by the wife, it's marital. If it's acquired by the husband, it's marital. There is an exception to that, which I'll let Christine cover in a second. Well, let me go ahead and cover it since I mentioned it. If you acquire an asset during the marriage by gift or inheritance,
Correct.
It is your separate property. So that's the only exception to stuff acquired during the marriage. But if it's acquired during the marriage from your paycheck, your labor, your efforts, your retirement account, whatever it is, that would be marital property, and that's subject to division in the case. Christine, separate property.
That's correct. So one quick thing about marital property. You're correct. If something is a gift, as in from a family member or an inheritance, it is going to be your separate property if you handle it properly.
Good
So
point.
remember that if you take that, whether it's an inheritance, it's a gift, and you commingle it into an account, meaning you put it in a joint account of any kind, your other spouse doesn't have to even have direct access if they are named on the account, because I hear it all the time. Well, she's never had a debit card from that account. There is no debit card. It's just a savings account. I just put her name on it in case I die. She's never put money in or out of it. It doesn't matter. If it's a joint account and you've taken that, what should have been separate money, put it into a joint account, it is now marital, period. No matter how much it was, no matter where it came from, no matter the source.
It's a good point, and I'll actually expound upon that a little bit more and say, don't commingle those funds. A lot of people will make that mistake. They will receive a gift or inheritance during marriage, and they will then put it, it might be in an account only in their name, right? They didn't put it in a joint account, but they put into account that contains marital money.
Right, or
And
they
now
continue contributing marital
exactly right.
monies post.
They put the money in Bank of America. It's only in husband's name. And then during the marriage, he adds money to that account. Well, guess what?
Now.
When you spend money out of that account, first in, first out rule, right, Christine? So whatever was in there first is what comes out first. And so you may have spent all your separate property portion, and now the only thing that's left is the marital part. So you don't want to commingle, and you don't want to put it in jointly titled accounts.
That's correct. So then there are other types of separate property, which is premarital assets. So anything that you had before you got married is premarital. And we can do premarital tracing on joint assets as well. So if you had a 401k account for 5 years before you got married, that portion, just that portion, that was in there prior to the marriage is premarital. So your spouse will not have any claim to that. And we have people way smarter in math than Jared and I that can help us do very scientific forensic
What
tracing.
are you talking about? Where'd that dig come from?
No, listen, when I'm telling you, when it comes to things like this, get the expert involved. Do not let two attorneys try to make their best guess. Hire the expert, get your forensic accountant involved that can do all the numbers and give you all the spreadsheets that don't make any sense to anybody except the people in the field. And then they explain it in layman's terms and say, well, the good news is that I know that when you got married, there was $10,000 in there, but you know what your premarital portion is? It's about $60,000. And I can show you the numbers of why, or you can just trust me and you just trust them.
Yeah, we need experts. And frankly, to be fair, I was joking. We actually hire experts all the time because I can't sit down with a calculator and figure out, okay, if my client had $25,000 in his account or her account before they got married, and we get divorced 20 years later, what is that $25,000 worth today? We have experts that can do that calculation and say, okay, here's the average market return, over these amount of years, and actually look at the statements and see how much to the penny actually
Correct.
that $25,000 is worth today.
Right. A
So
true
that is on a
scientific
separate,
number.
and that's what these folks need to know. It's not just what you brought into the marriage, but it's any interest and dividends and gains that have accrued on that separate property portion. But again, you got to keep it separate, and you can't commingle it with marital funds.
That's exactly right. Yep. So when we're doing those tracings, and like I said, if Jared and I didn't hire the expert, we're a paid advocate, right? So we have reason to, if there is a gray area, do it in favor of our client. So an expert is always going to be someone who the court views as neutral, and they're going to take their opinion even more highly weighted than our individual advocates, of course.
That's right. And, it's really important. If you're looking at this, it might be too late, but maybe it's not. If you can go back and get your statements as of the date of marriage, it's super helpful because we've seen lots of circumstances where people have been married a long time and they don't have the statement as of the date of marriage. Like they're trying to go back 20 years early and say, okay, I know I had money in this account before I got married, but I can't find the statement. If you can never produce a statement, because remember, the burden's on you to prove that you've got separate property. So
That's right.
try to get those statements together. If you're thinking about getting divorced and you have separate property, go ahead and start getting those documents together so we can prove your separate property claims. You have to prove it.
Sure. Or at minimum, let's try to figure out where we would get that information. Because I know a key example, because I've had several clients who work for AT&T, they have completely changed their entire retirement system multiple times. So it's called a pre-99. The pre-99 rolls into the post-99s, and the pre-99s don't exist. I will tell you that. If you're an AT&T or employee, pre-99s don't exist. AT&T has told me that through multiple subpoenas. They just don't exist. And so we've had reverse forensic accounting where we're able to say, okay, well, if this much grew, then it's implied this much was in there. So again, experts who are way smarter than me in the complicated math can even reverse back. It's not as great as a statement, of course, because statement is your best evidence, but there is a way you don't just have to give up and forfeit and say, well, now it's all marital, because something existed and it's undisputed that something existed, because they can always tell you at minimum the account origination date.
That's true. Great point. All right, we've classified the asset. So first step you got to do, you classify the asset as marital or separate property. Once we've classified what's marital, the next question becomes, well, how do we divide the marital property? And fortunately in Georgia, I say fortunately, I guess some people would prefer it not to be fortunate, but I think it's fortunate. We're an equitable division state. We're not a community property state. So what's the difference? Community property states, such as I believe California might still be a community property state, everything is everybody's, right? Unless you've got a prenuptial agreement, whatever's husband is wife's. Whatever's wife is husband's. It doesn't matter whether you had it before you got married. Doesn't matter whether you had it after you got married. And it's just pretty much a 50-50 division, right? And you can't make the argument.
Right.
You can't make the argument that it's not fair for the other side to get half. What's hers is hers. What's his is his. And it's straight up 50-50 division. In Georgia, we're not community property. We're equitable division, which means we divide assets according to what's fair.
Correct.
And that's a very vague, broad, objective term. But the reason I like it is it gives you the ability, if there's a certain fact pattern in your case, in your marriage or your situation, where it's not fair, equitable means fair, it's not fair to equal divide the assets, then you can make the argument. And the big one we see, obviously, is adultery. If you can prove that the reason for the divorce is due to one spouse committing adultery, you can at least make the argument that it's not fair, it's not equitable for the person that committed adultery to get the same amount of assets as the other party. But it's not always adultery. It could be that one party makes a lot more money than the other. If you got one spouse that's making, $300,000 plus and the other spouse has zero earning capacity, maybe they've just been a housewife or a stay-at-home mom or stay-at-home dad. We see that.
Yes.
And they never are going to make anywhere close to $300,000 per year. You could argue that it's not fair for the high-income earner to get the same amount of assets as a low-income earner because a high-income earner can more quickly replace the assets.
Yeah, and that is actually the scenario that I see being more successful, especially through like mediations when we're actually talking it out. Because, a lot of times if there is an adultery that's that severe that you think you're going to argue inequitable division of assets, that might be going to court. We're probably not going to, we might get it settled, we might not, depends on who the opposing counsel is. But for the common ones where it is one party just greatly out earns the other, and that earning capacity is so much greater, the argument is about replenishment. So if I have this pie and I split it in half today, one person has no ability to bake. They don't even have an oven. No more pies are coming. Where the other person owns a pie factory. That's how it looks. So is it fair when we only have one pie for the pie factory owner to get the one pie, half of the one pie? No, it's not. So that's usually the one that I think I more often see a true unequal division is this party is going to replenish at such a greater rate going forward that the other party really just deserves to get a better portion of what's available because the other party be made whole. I mean, sometimes within 6 months.
Well, and Christine, I will say it takes a creative attorney to come up with those arguments. I don't know if you see this in your practice. I assume you do because I see it in mine. But a lot of attorneys miss the opportunity to make that argument.
Oh, yeah.
A lot of attorneys will just assume if there's no conduct issue, if there's no adultery, there's no spending money on a girlfriend, there's no gambling problem, there's no hidden assets, that it's just going to be a 50-50 division. Stop. If your client or if your client's making substantially less than the other party and they're never going to have the same earning capacity, I think you should always make the argument
Oh, of
that it's not
course.
fair to do a 50-50. And I see a lot of attorneys miss that opportunity. But listen, everybody, I don't want you to get your hopes up. You need to go in assuming a 50-50. I will say we're talking about these exceptions. For the most part, I'd say 90+% of the time, most cases are resolved with a 50-50 division because that's what's fair. But if you have a circumstance, we pointed out a few examples where it's not fair to do 50-50, just know that you can make that argument in Georgia because we are an equitable division state.
And I do want to also point out that when we say not 50-50 or not equal, not equitable, don't be thinking 80-20 in your head. It's probably not going to go that way. A lot of times, what do we commonly see? A 55-45.
Correct.
A 60-40 is pretty much a stretch, depending on the asset. Like sometimes if it's a house, so it's a very defined asset, we know the amount of money, maybe a 70-30 on a single asset. So no, don't come in thinking, all right, well, it's not fair, so I'm going to be getting 80 and he's going to be getting 20 because he can go faster.
Yeah,
I'm talking a few points on that
Yeah,
percentage.
that doesn't happen often. I think so. We're early in 2025. I did settle several cases. Actually, one was through a trial where my client got more than half. But I think the highest disproportionate division I had was a 65-35, which is actually pretty good.
Yeah.
Certainly not the rule. But yeah, Christine's right. Don't go in thinking, hey, I should get 80, 85, 90%. Certainly not 100%.
It never
It's very rarely to happen. All right. So valuation of assets. So now we've talked about what's marital. We've talked about what's separate. We've talked about how we divide assets. What about how we value assets? Some assets obviously are very easy to value. A bank account, for example, is very easy to value.
Yep.
As long as there's not been any liquidation of the account, you just pull up the bank statement and what's in there is what's available to value. But sometimes we have assets that are a little more complex to evaluate. My biggest example, I think, that first comes to mind is a business.
Sure.
There's no one document that you can look at with a business that'll tell you what the business is worth.
Right.
There's a lot of documents you have to look at to see what a business is worth, and you got to look at the market trends, and we hire experts for that. We don't come up with our own numbers for businesses unless the parties agree on a number. Now, if the parties already know what their business is worth, great. But if they don't, we usually get an expert, and that expert will look at the business documents, the business bank statements, the accounts receivable, the accounts payable, the customer list, the market trends, other similar sales in the area.
Yeah,
the type of industry, other sales of similar businesses in the area, and they use all those factors to come up with the valuation of the business. So that would be an example of a more complex valuation other than just looking at a bank statement.
Sure. Property is generally pretty easy. We have property appraisers that can come out, but then sometimes you have commercial property. And then is the commercial property going to be leased with the current tenants in it? That gives it more value, of course, than a vacant commercial property. If you've got commercial property with several tenants of 5-year leases, that expected rent money is added in. Where if you've got a vacant property, it may be to the opposite. You may be losing money every month. So houses are generally pretty easy, but some commercial properties can be more complex. And then things like the pension, right? Valuation of a pension. Like we said, we have experts that can give us really, really good estimates, but that is an actual, an unquantifiable amount because you don't know how long someone's going to live. So there's just literally no way we can give our good estimated guesses. And we have people that can help us sort of get there. But again, a difficult thing to quantify sometimes.
Yeah, and I love the example of the pension because a pension, depending on the type of pension, it's paying a monthly benefit monthly until death. And so when we're talking about dividing that pension, unless it's a pension where the parties are just going to agree that once that spouse that has the pension receives the pension, they're going to pay a certain percentage of that pension directly to their spouse and their ex-spouse, right? Let's say that person's going to keep their pension. Well, to keep the pension, they've got to buy out their spouse. So we need to know what the value of that pension is worth today. For example, if it's paying $2,500 per month and this person's going to start getting that pension next year for life, what is that worth today?
Yeah.
And so we get a lump sum number. Let's say, and this is not actual math. $2,500 per month for a certain number of years does not equal this number. But let's say we determine it's worth $300,000. Okay, that person can keep the pension. The other spouse gets to keep an asset that's worth at least $300,000 or more to offset it. So I love the pension example. All right, last thing we'll talk about today for this topic are common pitfalls to avoid when you're dividing assets. And the big one that jumps out to me, and you see this all the time. Attorneys make this mistake a lot. I'm going to give the example of like a brokerage account that holds securities. So stocks, bonds, other marketable securities. And you agree as the husband or wife that you're going to pay to your spouse X number of dollars out of that account. That's a huge problem. Guess why? Because there is no cash in that account.
Right.
If it doesn't say you're going to transfer them securities equal to that dollar amount, you just agree to pay them cash. Well, guess what? You're now having to liquidate stocks or securities in that account to pay them X number of dollars. And guess who gets hit with the tax consequences for that? So anytime you're dividing assets that include tax consequences, you have to consider the tax implications, and the amount that you're paying needs to be either discounted to take into consideration the tax hit that you're going to take by liquidating that asset, or you transfer assets in kind. You don't transfer them cash. You give them stocks and securities in that brokerage account equal to that dollar amount.
Sure. I said the phrase often when we're looking at division in like mediation, not all dollars are created equal. So you can't, how many times do you see an attorney just give you a marital balance sheet and it has cash and retirement accounts, but there's no sort of offset of any kind. So you've got one person who's front loaded on just cash money available right now today, and the other person is taking all their monies in some sort of asset that can't be liquidated. And sometimes that's what you need. Sometimes my clients will say, I just want whatever cash I can get up front. Like, I'll worry about retirement when retirement comes. For now, I need every liquid dollar I can get. But that's not the exact same weight always as those other dollars that are not liquid right now, but definitely probably worth way, way more in the future if they sit where they are.
Yeah, and other things, common pitfalls. I mean, tax implications are a big deal, and I love my business owner clients. I love representing business owner clients, but sometimes they get taken advantage of in their divorces because they don't consider the tax implications. Let's say you're selling your business, and your business is worth $1 million, or whatever it's worth, and you sell it, and you agree to equally divide the proceeds from the sale of the business. You've just screwed yourself,
right?
Because guess who's paying the taxes from the sale? You are.
Yep.
And your spouse or ex-spouse gets to walk away with half of the proceeds, but they don't have to pay any of the taxes.
Right.
So if your business is getting sold or getting purchased, you got to take into consideration those tax consequences. Maybe you're selling a commercial property. Same thing. There's going to be capital gains taxes associated with selling that commercial property. Don't agree just to give your spouse or ex-spouse half of those proceeds. You need to discount that based on the tax implications.
Right.
Even if you're buying your spouse out of the business. I see business owners make this mistake all the time. Let's say your business has been valued this worth $1 million. Well, you're not going to pay your spouse $500,000. That needs to be discounted because you've got to continue to own and operate that business and pay the bills and manage the employees and, keep making dough in the factory to pay your spouse that amount of money. So it's always been a successful argument when I've made it. If the spouse is getting bought out, they should get bought out at a percentage lower than 50%. So just some very helpful tips and pointers on common pitfalls to avoid when you're considering asset division. Christine, got anything else to add on that?
I would say other common pitfalls. I mean, we're talking like super common. This is almost every single divorce case that we have. There's a marital residence. How often do you see somebody so emotionally tied to the marital residence, or maybe they have children but they need the stability and they take on a debt they have no idea they can't afford in a post-marriage divorce or shouldn't be affording. in a post-divorce situation. So just really take a minute to look at all your assets truly as assets. Don't have that emotional tie to, but my children were born in this house. Well, guess what? They're going to grow up and move out of that house one day, eventually, anyway, most likely. So chances are, like, you don't want to make that choice. Like, really just look at it as a financial sort of situation. Like, are you going to have enough to pay for this house? Do you need this much house? Are you going to be able to take on the yard and the pool? And I mean, how old is that roof? How old is the HVAC? Like, are there things, just because everything works fine right now today, if you really think about it, like, okay, what for the next 5 years, are there going to be potential issues with this house? And am I willing to take that on? So a lot of times I see people just out of sheerly wanting to hold on to something. The marriage is gone and their current like idea of their lifestyle is gone. And so that hold on to that, or the car, right? You financed the car during the marriage. It's only 2 years into the car note. And do you need to be paying $800 a month for a car note? No. So those are common pitfalls of trying to hold on to something, and you set yourself up for financial distress in
I
your
agree. I mean,
post-divorce
one of the
life.
good things about divorce is an opportunity to unload some of these financial burdens. And
Yes.
people always emotionally get tired to the house. I got to have this house. I got to have this house. And frankly, I think you're doing your spouse a favor in today's market, because today's real estate market is very uncertain.
Yeah.
Properties are sitting for longer. We don't know what they're selling for. Everything's more expensive. And so if you buy your spouse out from the house, meaning either give them cash equal to their interest in, let's say it's half of equity in the house, or they get a larger share of the remaining assets,
Yeah.
your money's all stuck in the house.
Mhm.
Guess what? That's no different than if they are a seller, it coming in off the street, right?
Yeah.
And you're giving them 100% of the fair market value. They don't have to worry about real estate commissions,
Right.
closing costs when you finally sell, what the house is actually going to sell for, what the maintenance is going to be, what the repairs. You're stuck with all that, and they're hopping and skipping and
They
jumping
just
down the road.
a check,
And they just
they're
got
going
a
to look for
check.
something new. Yeah.
Yeah, so think about those things. I love that example. I think that's all we have for today, guys. That's a wrap. Thank you for joining the Oxendine Law Podcast today. We are available on all major platforms. If you're on YouTube, make sure you hit subscribe, and let's make sure you thrive in 2025.